Please be seated. We're ready for argument in 23-344, 425 Soledad versus CRVI Riverwalk Hospitality.
The court, Mr. Kuhn will present argument for petitioners. Petitioners have reserved 5 minutes for rebuttal.
Mr. Chief Justice, and may it please the court. The innocent purchaser doctrine has been part of Texas law since long before there even was a property code. The rule is supposed to be simple. An unrecorded instrument is binding on a subsequent purchaser with notice, and to be entitled to the special protection of bona fide protection, the holder has to be a purchaser for value without notice or take title from one who was. As found at trial, that didn't happen in this case, and the innocent purchaser doctrine should not apply. But the Court of Appeals rewrote the law and got it wrong in 3 different ways. First, it adopted a new shelter rule that applies if any prior lien holder lacked notice. Second, it reweighed the evidence and held a lender to a lesser standard than a purchaser. Third, it held a former owner of a property which no longer had rights could litigate the rights it no longer owned. The court should reject all 3 of these missteps.
On that last one, I don't understand why the parties deal with it last. If you really think there's a subject matter jurisdiction problem, I would assume that would be your lead point.
Well, it's a standing argument, Your Honor, and which of course affects subject matter jurisdiction. So obviously if the court rules that there isn't standing, it doesn't have to write on anything else.
So I'm wondering, do you really believe it? Is it something you really think that this court doesn't have subject matter jurisdiction when you sort of tack it on as part 3?
No, Your Honor, of course we believe it. I wouldn't argue it if I didn't. I mean, essentially what we have in this case is we have a former property owner arguing the property rights of the easement. There's no case that I can find that that's ever been allowed, right?
Is it sort of like a situation when the president installs a new attorney general and all the pending litigation, they can switch out the name, you can substitute people, and maybe that wasn't done in quite the way it ought to have been done. I'm not disputing that, but is it a jurisdictional problem?
It's a jurisdictional problem, Your Honor. The party has to maintain standing throughout the litigation, including on appeal, and standing requires them to have an individual interest in the property. A former owner doesn't have that interest.
But
right?
your client obtained a judgment against the owner for attorney's fees.
Right,
They
Your
have
Honor.
standing to contest that.
That's the difficult part about this case, Your Honor. And you do have these lines of cases like the Allstate case, where you talk about when a party litigates a DEC action successfully, either defending or prosecuting, then they have standing still to litigate the attorney's fees issue. That's not what happened in this case. What happened in this case is we won at trial, we got an attorney's fee award. They didn't appeal the attorney's fee award. They sold the property before the briefing was even done, right? They sold the property before I filed my brief. The purchase and sale agreement was in February. I didn't file my brief till April. We just didn't know about it, or I would have moved to dismiss at that time, Your Honor.
Why isn't it analogous to a situation like when you have an individual party who dies during the course of a case and the rules allow for, at some point to file a suggestion of death and just substitute the entity who now owns the claim? I mean, it seems like there's an easy fix to this. Are you saying there's a fix, but they haven't done it, and therefore you lack jurisdiction, or?
Right. There's no case that I know of that I can find, Your Honor, where you can restore jurisdiction after it's been lost. And this court has said subject matter jurisdiction and standing has to be decided on an issue by issue.
But what about in the case of a suggestion of death? Is it a person dies and so there's no jurisdiction and you can't restore it in King's X?
No, Your Honor. In that context, we allow a substitution of the estate or whoever else is taking that possession, and you try it as if they're still alive, essentially. And they've brought up this idea of Rule 7. And could they have used Rule 7 to sub somebody out? I can't find any cases where you sub out the appellant, right? What the court has said before is if the appellant no longer has an interest and you need to sub somebody out as the appellant, what you're supposed to do is go back to the trial court and set aside the judgment and enter a new judgment. The cases they cite are where the appellee has been subbed out. And the appellee doesn't have to have standing. Their standing to come to court is because of their relationship to the judgment, right? And so you can sub out that person, whoever has that interest, right? But they didn't do that in this case. They waited 2 years. They waited till after the judgment was entered, and then they told the court, oh yeah, we sold this property 2 years ago.
So
Right.
you're saying they may have an interest in the attorney's fees award, but not in the underlying question of the easement?
That's the difficulty, Your Honor, is how do you treat that, right? And I can't find any case that's ever decided that. But what I would say in this case is they didn't appeal the attorney fee award. They
By
didn't.
appealing the judgment, and if they win, the attorney's fees award goes away. That's another way of appealing.
That's
attorney.
essentially the argument they've made, Your Honor. And if you look at what happened, look at the briefing I looked this morning in the Court of Appeals, right? They briefed 6 or 7 issues. The last one was an argument about attorney's fees. And the argument was we couldn't tack on a claim to the deck action to get attorney's fees. But then they didn't brief it. It's nowhere in the brief. They don't mention it again. So we argued waiver, briefing waiver. And in their reply brief, they argued, well, we're allowed to argue the merits of the deck action, and if you find for us on the merits of the deck action, then of course you're supposed to reverse the attorney's fee award or send it back. But now they're arguing the opposite. They're saying like, oh, well, because we have the damage award, we can argue the merits of the deck action. Now, if the court decides that, what it's going to be saying is that parties that don't have an interest in the property can litigate the merits of property rights.
If you were to have irrevocably abandoned the attorney's fees claim, then they wouldn't have that stake, I guess.
I'm sure that's true, Your Honor. Of course, we didn't know at the time.
But you know now. You want to do it?
Well, it's after the judgment, Your Honor. I mean, the Court of Appeals has already ruled on the merits, and we're trying to...
Still have the question, this court needs jurisdiction as well.
Right, Your Honor. I don't know that I have authority for my client. I could ask, but...
Like if you're going to make an argument about subject matter jurisdiction and it's hanging on that, that would be the way. But otherwise, I'm not quite sure. It seems like it's either a substitution or they have an interest in the fees.
The
But
court has always said that standing is issue by issue. So if the court wants to write a rule that allows them to challenge the attorney fee award, I mean, if you look at the recent case that I cite in the reply brief, the Savannah Court out of the Fort Worth Court of Appeals, it's a case where it's a little bit different, where the developer, they sold the property, went back down. The developer continually argued, we don't own this property, right? You shouldn't be able to get a deck action against it. In this sense, it's more like the Allstate case, right? The court enters an attorney's fee award against them, or enters judgment against them. On appeal, the Court of Appeals says, hey, you don't have authority to enter this property issue because they don't own the property. So we throw out the deck action. Now, what does it do with attorney's fees? It said, because we've thrown it out, we're going to send it back to the trial court to figure out what it should do about attorney's fees when there never was an interest. That's what the Fort Worth court did. Now, this is slightly different in this case, right? In this case, I think that it's better served. I mean, I don't think you can let somebody who doesn't own the property litigate the property rights. And that's what's...
Someone that has a judgment against them for fees is entitled to raise any argument that they've properly preserved to say, we don't owe the fees.
But that's the difficulty, Your Honor, because their argument is going to be the merits of the property rights. And so what you're going to be saying is...
What the determination about the merits of the property rights might be in connection with this case might not bind another property owner, right, the subsequent owner. And maybe on that note, we should get to the merits if that's the main thrust of
Right.
the standing here.
Right, Your Honor. Well, I think all three are important, but we definitely argue that we should win on all three. And I argue all three, Your Honor, because I know the court is not inclined to accept waiver necessarily as an argument. But I think if there ever was one, this might be one to look at. But if you look at the innocent purchaser doctrine, at court, the court found that CRVI was not a bona fide purchaser because it had a reasonable inquiry by a prudent purchaser would have discovered and would have had notice. So it had notice of the easement. And that's consistent with what this court said in the API Pike case. A purchaser with notice of an adverse interest can't be deemed an innocent purchaser, right? And then beyond that, they didn't acquire the property from somebody who had innocent purchase status. They bought the property from HEI. And both HEI and its lender, Merrill Lynch, knew about and accepted the easement. In fact, they had something signed by 425 when it bought when they were going to put the loan out and bought the property, confirming that the easement remained in full force and effect.
what difference does Merrill Lynch make?
Well, Merrill Lynch was just the original lender, and Merrill Lynch had notice of it. And so the idea is if they got what Merrill Lynch had, right? Merrill Lynch was in the same position that they were when they bought the note. Merrill Lynch was able to easily find the easement.
But we can't just attribute whatever Merrill Lynch may or may not have known to them, can we?
That's an interesting question, Your Honor, and it's an argument we haven't really pushed, and one that the trial court found. There's two things I want to say about it, about this sort of imputed knowledge. The first thing is, there is this, if you look at the UCC, it's 3.203 of the UCC, says that a transfer of a note, the transferee has the same rights as the transferor. And there is a line of cases, a series of older cases. The one I wanted to give you is Vogel v. Zip, 90 Southwest 2nd, 688. That's an Austin Court of Appeals opinion from 1936. And it has to do with the idea when there's a transfer of notes, it says specifically the transferee can't assert the innocent purchaser doctrine. But that's in the situation of a note, right? So you're talking about the note being, against the note holder. This is slightly different because obviously, we're not the note holder. But the thing I would say second about it is it doesn't matter. It should be harmless error even if the court got that one wrong, because they didn't purchase the property from Crown. So it doesn't matter whether or not Crown had notice or would have been an innocent purchaser. The trial court got the analysis exactly right on the innocent purchaser doctrine. It looked at when they bought the property, and it said they had actual notice, right? Their argument, they say we're trying to change the law. It's the exact opposite. What the trial court found was that a reasonably prudent purchaser should have found this property. And that is what every decision has said from this court going back 150 years ago. That's what you said in the F.J. Harrison case. It's what you said in Flack. It's what you said in, any case you've done. This reasonable, prudent purchasers, that's the law, right? They're trying to change the law. And if they're right, they have no duty to look, right? They have two different instances here. The first is when they buy the note, right? And when Merrill Lynch bought the note, when they made the loan, and HEI, they found it, right? They found this easement easily. When they come along, they want to say, well, we're going to rely on Merrill Lynch. We didn't need to look. We just relied on Merrill Lynch to give us everything that we needed. And if you look in the handouts I gave you, under the assumption agreement, they specifically agreed not to rely on Merrill Lynch, and that they would do their own due diligence, right? And then come along when they go to buy the property through the receiver, what they say is, well, we relied on the receiver to give us whatever we want, whatever we would need. We didn't need to go look. But if you look in the handouts at H, the receiver said, I don't know everything. I'm not giving you everything that's complete. I'm just a receiver. You need to go find this stuff. And they specifically agreed to take on their own duty, right? So their argument is, let's change the prudent purchaser requirement, and let's say that if we buy from a receiver, have no duty, right? And that's not how a receivership works. And that would be a fundamental change to the law, which the Court of Appeals just kind of glanced over.
I hear all of that, but it probably should have been recorded. And it's true that something that's not recorded can impose obligations with notice. Why shouldn't we read that with notice pretty rigidly, pretty strictly against the person who's claiming that someone was on notice in order to encourage recording? It should be possible for people who are buying property to just go and do these title searches without finding the breadcrumbs and seeing where they lead, right?
I understand, and that's the idea of the recording statute, is to prevent the secret title, right, which is what you're getting at.
Or just anything that's going to affect my substantial rights that turns out it was there, and somebody, years later is going to say, you should have known, you should have followed the breadcrumbs.
But that's the law as it's encompassed in the Recording Act. The law has always noticed. One of the things the court may want to...
My question is, how should we read notice? Should we be generous to the person who is saying that someone else should have been on notice, or should we be strict? Which one is going to better serve the larger interest of
This court has always said that's a fact question, right? And I think it's much more, it's a case-by-case analysis, the court has said, right? In the case of an easement, right, if you're ever going to change the law, don't change it for an easement, because that's an instance where one's more likely not to have been recorded for whatever reason, as opposed to a possessory interest. And two, when there's a case I wanted to point out, because it's so simple. This court said it in F.J. Harrison. There's a Miles v. Bodenheim case, which I cite in the brief. It's 193 Southwest 2nd, 693. And it's a Texarkana case from 1917. But it's such a simple issue, and it's an alley on the back of a property. And they ask him, did you see this alley that cuts across? It was unrecorded. And the question is this easement. And he says, well, I may have noticed it was being used for horses and buggies, right? And the court said, look, whether you noticed it or not, you have actual notice of it because you have a duty. And if you look at both this court's opinions and all the opinions I cited from other jurisdictions, on an easement, the question is, when you're buying an easement and there's open use by a third party of the property, do you have a duty to find out why they're using it and on what basis? And if the answer is no, then you're going to destroy easement law in Texas.
Any other questions? Thank you, Mr. Kuhn. We'll hear from the respondent.
May it please the court, Ms. Weber will present argument for the respondent.
May it please the Court. The Court of Appeals held that the shelter rule applies here, and the parking garage is not burdened by the parking agreement because Riverwalk purchased the garage through a receiver's sale to liquidate the collateral for Crown's loan. And second, Crown was a bona fide mortgagee who acquired its B note without knowledge of the unrecorded parking agreement. And
Was there evidence in the record that Crown or one of its Crown entities had a couple of appraisals in its files, in its own files, that had in the appraisal talked about the easement and that it was burdened by the easement?
Those came after Crown had purchased the B note. So the order was Crown purchased the B note in 2008, 2010 appraisal that had the reference, 2012 appraisal that had the reference, 2013 Riverwalk purchased from the receiver in the liquidation of the collateral. So at the time that Crown purchased the B note, those appraisals did not exist. And the trial court made no finding. Mr. Kuhn says this is a fact question. The trial court, the fact finder, made no finding that Crown had any notice or knowledge at all. The sole basis that the trial court gave for finding Crown not to be a bona fide mortgagee
Right,
was
and that might
imputed.
matter for suit on the note, but for obtaining the lien, for basically obtaining assets to satisfy the lien, at that point, when the receiver sold those assets, Crown did have because it was trying to figure out what the value of the property was, right?
But at that point, it is not relevant because Crown acquired the B note without any notice at all. Four of those existed without any notice at all, no findings that it had any notice at all. And then at that point, it was a bona fide mortgagee, irrevocable, set in stone. It was a bona fide mortgagee. And when that collateral was sold to satisfy its lien, then that bona fide innocent purchaser status passed to the purchaser through that liquidation sale, which was Riverwalk.
But I thought it didn't foreclose on that lien.
I'm glad that you brought that up because the shelter rule, that's a line that petitioners have asked this court to draw.
Well, you're saying there are two different interests here. There's a lien interest and then there's the purchaser interest. And if you're going under the purchaser interest, I don't see what difference it makes whether you have notice or not under the lien interest.
Well, I think that's a fundamental application of the shelter rule doctrine as applied by Texas courts for decades. They say
that's not a doctrine that's been applied by Texas courts for decades.
Well, Your Honor, yes, they say that. Perhaps not every Texas case uses the term shelter doctrine, but it's an application of bona fide mortgagee principles. And the Texas courts have applied it for decades, including, here's one from 1896, Van Berkeley versus Southwest Manufacturing Company, 39 Southwest, 1085, 1088. The assignee for value before maturity of a negotiable promissory note secured by mortgage who has no notice of any vice in the security will take the mortgage free from equities existing between the original parties to such an instrument. We think the authorities are clear.
Even if the ultimate purchaser has actual knowledge.
100%.
And that's,
That's,
Hardly
but,
makes sense to me.
but that is how it works, and that is the
But
only
we've
way.
never said that, so we've got to decide, should that be how it works? And
Well-
why should that be how it works?
Because that's the only way to preserve the interest of the bona fide mortgagee who loaned the money or paid for value, and the evidence shows that Crown paid $22 million to purchase the B note. The reply brief says they didn't advance any money, which is just false. They paid $22 million, and the only way to preserve the value of that instrument by a bona fide mortgagee is to ensure that the purchaser of the property that is being liquidated to satisfy that mortgage retain that bona fide purchaser status.
So is the easement extinguished? Is it just gone? I mean, that's a formal matter. Is it still
It is
sort of
just
sitting
gone.
there but unenforceable, or would you say it's just extinguished by
It
the
is
fact that?
extinguished, it is extinguished, yes.
I mean, this seems like something we learn early in property classes.
That is
If the
exactly-
bona
I've
fide
been
purchaser is protected themselves, or if a bona fide purchase extinguishes the property right. Those are
Yes.
two very different regimes.
Well, a bona fide purchaser is not bound by, bona fide purchaser and its successors are not bound by some unrecorded or property interest, which is what the easement was here. And the shelter rule.
There's a difference, obviously, between them not being bound and the property right that's encumbering the property being extinguished.
Well,
And those are, even if they get you to the same place in many cases, those are two very different ways of thinking about what's happening here. And it's just sort of surprising that we didn't all get the answer to that in the second month of property class.
Well, this court has spoken, I'm sorry, I forgot which one of you said that no court, y'all have not spoken on it, but this court spoke in the Moran versus Adler case, dealt with the notion of a bona fide mortgagee being protected and its purchaser, even if the purchaser has notice, its purchaser acquiring clean title, because that's the only way to protect the mortgagee. And Chief Justice Jack Pope wrote the opinion in Moran versus Adler. It's cited in the parties' briefs. And here's what he said. It advances the principle that the holder of a parent title will be protected over the holder of the secret title. And there's a bunch about this parking agreement that reflects affirmative action.
But in order to protect the innocent buyer, the original innocent buyer, you'd have to also protect, I guess you'd have to protect it all the way down the chain. Like you could never come back, even because then
it's done.
It's immediately less valuable if there's ever the possibility that it's going to spring back into existence.
Your Honor, when unrecorded property interests get passed over because of a bona fide transaction, either a bona fide mortgagee liquidation to a purchaser or a bona fide purchaser, when it gets washed out, it gets washed out. And that's why this is...
But talk about that, because in this case, the mortgage didn't get washed out because it didn't go through foreclosure and public sale.
I do want to talk, I'm glad you asked that question, Justice Bland. The Texas case law addressing this issue of bona fide mortgagees does not distinguish between the vessel for liquidating collateral and selling it to satisfy a lien. It doesn't distinguish between a sheriff's sale, foreclosure sale, execution, receivership, any other vessel. No court has recognized the bright line that Mr. Kuhn asks you to adopt to say that, sure, bona fide mortgagee, shelter rule, yay, high behind it, but ooh, if it's a receivership sale, no, it's not. And at least two cases, no court has said no, and at least two cases have indicated that yes, it is. But first, let me back up a second. The receivership that was in place here was pursuant to Chapter 64 of the Texas Civil Practice and Remedies Code. It is a comprehensive statutory scheme that has all manner of bells and whistles for receiverships and court authority and court oversight and approval. And that is one of many tools available to parties dealing with a default situation for a debtor. Sometimes if there's a debtor in default on property, the best course is to foreclose on it, sell it on the courthouse steps the second Tuesday of the month. Sometimes the best course, depending on your circumstances, is to have a bankruptcy, like in the prior case. Sometimes the best course, particularly if you have a situation like this where the debtor is a going concern, it was a hotel, and the best course, the parties here determined that the best course in a situation in default, the hotel is in distress, is to appoint a receiver to come in, manage the hotel, right the ship, and then liquidate the collateral in a commercially reasonable course over
Right,
time.
and when you took some of that liquidated proceeds in satisfaction of your lien, as opposed to going through the foreclosure process, did you agree that what you received included title with permitted exceptions, including easements?
Okay, well, it is important to, who's we? It is important, I think, to distinguish between Crown, the holder of the B note, who is a bona fide mortgagee, and Riverwalk, who purchased from the receiver, did not purchase from HEI, that Mr. Kuhn said, purchased from the receiver in the liquidation sale.
But all they can purchase from the receiver is what was owned by the person that conveyed the right to him. That's what we said in Neal. So they're not purchasing from the receiver. They're purchasing through the mechanism of the receiver, the property from the prior owner who knew about the easement.
But under bona fide mortgagee principles, that if you have a bona fide mortgagee and the collateral is liquidated to satisfy the lien of a bona fide mortgagee, then that
Right.
passes a clean title.
But it wasn't. It was not. It was not foreclosed upon, and
But-
instead
but-
there was. If I can just finish. Instead there was a deed that you accepted it, as Justice Bland mentioned, subject to any easements. So through the receiver from the prior owner.
Okay, Your Honor, in order to do that, in order to engage in that analysis and look to whether or not Riverwalk purchased subject to easements, this court would have to reject entirely the entire body of law of bona fide mortgagee.
Why? They can still benefit from that if they foreclosed.
But that distinction has never been recognized in Texas law, and at least two cases indicate that, well, first of all, you'd be taking away a tool from courts and parties.
Well,
Currently,
but tools have upsides and downsides.
They have
and
upsides and
people can balance
downsides.
those and.
let me talk about two cases that specifically apply the bona fide mortgagee construct in the context of a receivership. One is the O'Farrell versus Coolidge case. We cited in our brief, and then in the reply brief, petitioners say that oh, no, it doesn't really apply. Ms. Weber's wrong. It doesn't really apply in a receivership context. And so what's the line? I didn't go to a fancy law school, but I'm confident of my representations regarding the case law. What happened in O'Farrell versus Coolidge, the unrecorded issue there was an undivided interest in an oil and gas lease. The property interest was 1/2 of 7/8 of a leasehold interest, and Mr. O'Farrell claimed through an unrecorded instrument a quarter interest in that. So that's the easement, that's the unrecorded instrument, and then there's the property interest, that's the 1/2 of 7/8. There was a bank, Art Bank, gave the original mortgage secured by the leasehold. It was assigned then to Coolidge. Coolidge was a bona fide mortgagee because it had no notice. The opinion analyzes all of what did Art know? What did Coolidge know? Coolidge is a bona fide mortgagee. O'Farrell is making a claim to his 1/4 interest. The case is in litigation. During litigation, a receiver is appointed, and the receiver liquidates the collateral, the interest, the undivided mineral interest, the 1/2 of 7/8, liquidates that, which Coolidge was now the bona fide mortgagee. Well, there were shenanigans involved in the receivership because the receiver was Coolidge's lawyer in the litigation. And who bought it but Coolidge at the receivership sale? So Coolidge is a bona fide mortgagee. Coolidge's lawyer is the receiver, Coolidge is the purchaser. The court did not directly analyze, did Coolidge as purchaser carry forward the bona fide status of Coolidge as mortgagee? But what the opinion does is give Coolidge the money. Now, if Mr. Kuhn is correct and receivership doesn't carry, now by this time, they're in litigation. Coolidge knows about, he's in litigation with O'Farrell. He knows about the defect in title, the unrecorded 1/4 interest that O'Farrell claimed. So if petitioners are correct and receivership is not a vehicle liquidating collateral to satisfy a lien, cannot be through the vessel of receivership in order to carry forward the bona fide mortgagee status, then O'Farrell would have gotten his quarter interest as part of that transaction. When you sold, that wasn't a bona fide sale, and so I get my quarter interest, but that is not what happened. The court simply analyzed, was this a legitimate sale? Was this yes, it was their impropriety because of the lawyer?
Can I interrupt? I'm going to oversimplify it because I just want to make sure I understand. Does, in your analysis of what the shelter rule is and what the shelter rule does, whether it matters if there's a receivership, a lender, a mortgage, any of it. So if MSPA owned the office tract, the garage, and the hotel, and sold the office tract to 425 Soledad, and gave them the parking agreement to use the garage, but it was never recorded. And then Riverwalk comes along and pays cash for it. No mortgages, no receivers, no lenders. They just pay cash for it. It's not recorded, and they are an innocent purchaser. They have no idea that there's this agreement out there. Is it your position they're an innocent purchaser and they take that parking garage with unburdened by that parking agreement?
Yes.
And then your position is if then Riverwalk turns around and sells it to Acme Corp., and Acme Corp. Does have knowledge of the parking agreement, it is nevertheless unenforceable against Acme Corp. Because of the shelter rule. That's how you...
Shelter rule is, that's just a plain vanilla bona fide purchaser.
No, because once it goes from Riverwalk, who is the innocent purchaser in my oversimplified hypothetical, then Riverwalk sells the parking garage to Acme Corporation, but Acme Corporation has actual notice of the parking agreement and that Soledad's people are parking there. And your position would be, it doesn't matter if they have
Doesn't matter.
it's extinguished.
It's
and
gone.
that's where the shelter rule kicks in as sort of a down-the-chain supplement to the innocent purchaser doctrine.
Correct, Your Honor.
And so whether there's a receiver, whether there's a lender, whether there's a mortgage, a mortgagee, none of that matters, or does it? Does that make any difference in just understanding what the shelter rule does?
It doesn't make any difference, Your Honor, because the shelter rule is really just an application of bona fide concepts in the situation where it's a bona fide mortgagee and the liquidation of collateral.
But
And
you said a bona fide mortgagee, and what I'm saying, does it matter?
it doesn't matter.
A
It
bona
doesn't
fide
matter.
purchaser would
Bona
be
fide
the same.
purchaser. And my time is running down, and I want to make sure that I address a threshold question on the merits, and that is whether this instrument is an easement at all. And the answer is no. And here's why. What an easement is a grant it's a real property interest that allows the owner of a dominant estate to enter and use the servient estate for some specific purpose. And the parking agreement doesn't do that. It doesn't grant the owner of the dominant estate, the office, the right to enter and use the parking garage for parking. And here's why. Because it only grants third parties the right to enter into future leases. There's no actual direct grant of the owner to the owner of the dominant estate to use the parking garage and park there. It says, I'm going to make available, no present words of grant, I'm going to make available parking spaces that in the future third parties can make monthly contracts for. And that distinction that there is required some future contracting, the best indication of that in the record, well, the plain terms of the parking agreement make that clear. But in addition, even Mr. Hans Lindberg, the gentleman who owns 425 Soledad, who signed the parking agreement, even he had to have a separate monthly parking contract in order to enter the servient estate and use it for the particular purchase of parking. That's at Defendant's Exhibit 22 at 3 Reporters Record 472. And the fact that it requires, that it doesn't grant the right to enter and use the servient estate means that it's not an easement, but it also means that it is void as violating the rule against perpetuities. Because one of these future leases, future instruments, future contracts is required in order to enter and use the servient estate. And what is it? That an unborn widow or a fertile octogenarian could, at some point in the future, need to execute one of these monthly contracts in order for there to be entry and use into the servient estate.
Could you briefly describe, but you spent so much effort explaining why it ought to be the receiver that we're talking about, but what if we think it's HEI that's the relevant transferor? Do you still win or not?
HEI is not the relevant transferor, Your Honor.
Again, my premise is we conclude that it is. Do you still win or not?
Yes, Your Honor, I do. I do because for a bunch of different reasons down the line. One, because it's not an easement. Two, because the rule against perpetuities makes it void.
Strictly on the notice point.
On the notice point, there was never anything that triggered an inquiry by Riverwalk when they purchased the,
By that point, the 2010, 2012 appraisals were long in the past.
There is no evidence that they had actual notice of the recital on page whatever, 75 of these giant appraisals, and there was a lot of testimony about what they were for. But I want to specifically point something to the court, and that is some of the efforts that made this really a secret title. And that is, if you look at tab B in Mr. Kuhn's booklet, is a snippet from the Shared Facilities Agreement. The Shared Facilities Agreement refers to the parking agreement, but like the parking agreement, it was not in a form to be recorded, and it wasn't recorded. And not only that, but there's a provision in it, paragraph 14 in it, that says, "Thou shalt not record this. No party shall record this." And what is super unusual and reflects secret title is that as part of the transaction of MPSA to 425 Soledad, as part of that whole transaction and the purchase of the office building, the parties needed to have reciprocal easements to use the tunnels. Each one needed an easement from the other to use the tunnels. Tab C is a map that shows the tunnels running on the tri-corner like that. Both sides needed an easement. Both sides gave each other an easement, but they did it in this form. There is a tunnel easement through which 425 granted to MSPA the right to use tunnels that it needed, and that's recorded. And then the reciprocal easement isn't in the same tunnel easement document. It's hidden in the Shared Facilities Agreement that was never recorded. And so if you wanted to know, why are people using that tunnel? And you go to the tunnel easement, oh, those are just the MPSA people. The fact that it was hidden in the Shared Facilities Agreement rather than being in the tunnel easement, do them all in one place, is another indication of nothing was regular about this parking agreement.
Any other questions? Thank you, Ms. Weber.
Thank you, Your Honor.
Mr. Kuhn, you have 5 minutes.
We aren't the ones trying to change the law, they are. And I want to start with Justice Boyd's analogy, because I thought I knew where he was going with it, and you tweaked it a little bit, so I'd like to change it. Under their interpretation, let's assume the purchaser, which could be Riverwalk in this case, knew about the easement. Under their rule, they would still take it absent the easement and extinguish the easement because it doesn't matter how they got it, right? Under the...
Well, no, their position is somewhere along the way, there's got to be an innocent purchaser that takes for value. right?
But who would it be in that scenario, Your
The
Honor?
great, let's say, is it MSPA or MPSA? I can't remember
MSPA.
now. MSPA owns all three. You buy the office and you do the parking garage, parking agreement. And the parking agreement's never recorded. And then Riverwalk comes in and buys the garage and hotel, and they're innocent purchasers. They don't know about this parking agreement, nor should
Right.
they have known. Do they take as innocent purchasers?
Yes, under your
without
analogy.
that agreement?
Just under your analogy, right? If they don't know, they can be an innocent purchaser.
Okay,
But
then-
that's not what happened here,
Right,
right?
then the question is, if Riverwalk is the innocent purchaser, in my oversimplified hypo, now they sell it to Acme Corporation, but Acme knows all about this parking
They get
agreement.
they get it under the shelter rule.
So you do
it's not,
agree-
there is no such thing as a shelter rule. They get it under the innocent purchaser.
Well,
The
it's-
innocent
it's-
purchaser rule is you have to get it if you purchased it without notice, so that's your first person, or if you are a successor in interest to someone who was. If you bought it from
Even
somebody.
if you have notice?
Even if you know.
Okay, so
Right, but
you're-
that's not what happened, right?
So you agree with the basics of the shelter rule that she's laid out, that we've just laid out in that hypo?
No, I mean, your hypothetical, right, is part of the innocent purchaser rule. There is no such thing as a shelter rule. People talk about the
You
shelter
agree
rule.
with it, you just call it part of the
want-
innocent
Well,
purchaser
I mean,
rule, right?
essentially-
And I understand you think the terminology.
You can use
differences-
shelter as a verb under the innocent purchaser rule, that's fine. But what my point is, what they're saying is, like, tweak your analogy just a little bit, right? Riverwalk purchases it directly from HEI. Riverwalk knows about it. They know about the easement. Under their new rule, they would still be free of the easement because a prior lien holder, they say, didn't have notice. And that's not how the innocent purchaser doctrine
So for
works.
you, the distinction is that the prior innocent party was a lien holder, not a purchaser.
Well, no, the idea, the way the innocent purchaser doctrine is supposed to work is its chain of title, right? And so did you take title from somebody who was an innocent purchaser, or were you yourself an innocent purchaser, right? They took title from HEI. So take your analogy, this is what I'm gonna say. Let's say they know about the easement, right? They pay off the note when they buy the property. They would say they're still in it, that gets rid of the easement because they relinquished this lien of somebody who might not have known about it. That's what the Court of Appeals
Even though
held.
the borrower under the note had knowledge, that's what you're saying is the
Even if the
distinction.
purchaser knew 100% and the seller knew 100%. There is no innocent purchaser doctrine if nobody in the chain of title is innocent.
Well, and what you're saying is, it's okay to have an innocent purchaser doctrine, you just can't have an innocent lender doctrine.
It's not exactly right. I mean, the way that the innocent purchaser doctrine works, it depends on the manner of transfer. Who did they buy who did they buy it from, right? It can't apply in a receiver sale because a receiver gives you what the borrower had. And in this case, the borrower had the easement. So you can't give them something they don't have, right? A receiver doesn't work in the innocent purchaser doctrine. The O'Farrell case, I know I briefed this is the problem when you're dealing with cases that are 75 years old. It just has nothing to do with what their argument is. The innocent purchaser part of that case happened years before the receivership. It had nothing to do with the receivership. It had to do with that they bought it without notice, that they bought it directly from the bank without notice, right, the note. The receivership happened 2 years later when, and the issue was the appointed receiver, she noted, was the lawyer, right? It had nothing to do with creating the innocent purchase doctrine. And it makes no sense to, because the way a receivership works, and if you look at tab H, 4.4F, I mean, at 4.4, what they agreed to. And this is what they agreed to. They agreed that any easement, whether recorded or not, right, they had to find. And if they didn't, if you look at the very last of it, what happens? If it doesn't get fixed, they waive such condition, accept such title as seller is able to give without any reduction in the purchase price. They agreed all along to take this subject to unrecorded easements. They just don't think they have a right to do any other notice requirement that's always been required in Texas law.
Any other questions? Thank you, Mr. Kuhn. The case is submitted, and the court will take another brief recess.
All rise.